Hello, friends. If you were born before 1963 and you own your home, there are 5 quiet ways your equity is at risk in 2026, and every one of them runs on notices, deadlines, and forms that are easy to miss. Here is the number I want you to hold. $48,000. That is what a homeowner can pay over 10 years in property taxes and insurance on a reverse mortgage that was supposed to eliminate the housing payment. And that is only one of the 5. The IRS has its own clock. Your county has its own. Medicaid has one that can wait years and show up after death. The notices exist. What does not exist is anyone whose job is to call you and explain how to stop it. This is not one problem. It is 5 completely different systems. The IRS, your county tax office, your reverse mortgage servicer, and your state Medicaid agency. And each one has its own rules, its own calendar, and its own way of reaching your home equity without picking up the phone to warn you first. Grab a pen. I'm going to walk through all 5. Mark the ones that apply to you, because if you own a home and you live on retirement income, at least one of these is yours. Here is why this matters right now. These rules shift. Local calendars move. County sale dates change from one year to the next, and not a single one of these agencies is funded to send you a plain English letter before the damage starts. The people subscribed here find out in time. Subscribe now and let's get into it. Before we go any further, I need to address something, because people hear a topic like this and immediately sort themselves into one of 2 groups. The first group is comfortable. You have savings, real equity, maybe a paid-off house, and you figure this kind of thing is for people in worse financial shape. The second group is on a fixed income, counting every dollar, and you've learned to assume the serious protections are always for someone else. Both of those assumptions are wrong about at least one of these 5 items, and on every single one, I'm going to tell you exactly which group it hits hardest and what to do about it. The comfortable group is going to be surprised by number 2. The fixed income group is going to be surprised by number 5. And that last one, number 5, is the one families usually do not discover from a bill. They discover it when they think the house is finally being passed on. Stay to the end for that one. Number 1. The IRS tax debt you don't think is large enough to matter yet. Most people assume the IRS only files liens on people with massive tax fraud problems, 6-figure debts, criminal investigations, that kind of thing. That assumption is wrong, and it is costing quiet money every single year. Here is how it actually works. A federal tax lien, that's the government's legal claim against everything you own, including your home, kicks in after 3 steps. The IRS assesses the tax you owe. They send you a bill called a notice and demand for payment, and then you don't pay it in full on time. That's it. Once those 3 things happen, the lien exists by law. The IRS does not need to file anything in court for the lien to be real, and if the debt stays open, they can file a public notice of federal tax lien, which clouds your title and shows up in any search on your property. Here is the part that catches retirees. If you're collecting Social Security and you have other income, a pension, required minimum distributions, even investment gains, your combined income can push your Social Security benefits into taxable territory. The threshold is $25,000 for a single filer, $32,000 for a joint filer. Those are not high numbers. And if nothing is being withheld to cover the tax, you end up with a balance due every April that you didn't plan for. Who does this help most? Both groups. If you're on a fixed income, under-withholding on Social Security is the most common way a small tax balance turns into a recurring problem. If you're comfortable, a bigger required minimum distribution creates a bigger tax bill, and the assumption that you'll settle up at filing is exactly how a balance becomes a collection issue. Now the math. Say the shortfall is $190 a month. That's $2,280 a year. Leave it alone for 3 years, and you're looking at $6,840 that could have been handled before it ever became a debt. Someone in the comments asked about a situation a lot like this. A retired electrician named Charles, 69, in Mesa, Arizona. Social Security and required minimum distributions were creating a federal tax shortfall every year because nothing was being withheld from his benefits. A manageable gap of about $190 a month turned into a year-end problem, and then a collection problem. He used Form W-4V, that's the voluntary withholding request you file with Social Security, to start withholding at one of the 4 available rates, 7%, 10%, 12%, or 22%. And he used the IRS payment plan channel to deal with the existing balance before it grew any further. $190 a month, $2,280 a year, $6,840 over 3 years that never turns into a back tax problem in the first place. Here is your action step. Log into your IRS online account. Confirm whether you have a balance. If you do, request a payment plan. You can do that online or by calling 1-800-829-1040. Then stop the bleeding going forward. File Form W-4V to start withholding from your Social Security, or use Form 1040-ES if you need to make quarterly estimated payments. The 2026 estimated tax due dates are April 15th, June 15th, September 15th, and January 15th, 2027. And if the IRS has already filed a lien notice, you have 30 days from that notice to request what's called a collection due process hearing, a CDP hearing, using Form 12153. That 30-day window is real, and missing it limits your options. Nobody calls you to explain this. The notice arrives, the clock starts, and the system assumes you know what to do next. That is number one. The debt is one problem. The next one is what happens when that debt starts attaching itself to the house. Number two, the lien filing that follows the house into a closing. Here is the misconception. I'll just sell the house later and clean it up at closing. People assume a tax lien is a nuisance that gets swept up in the paperwork when the property changes hands. The reality is messier and more expensive than that. If there is a federal tax lien on your home, you must satisfy the lien before you can sell or refinance. If there is equity in the property, the lien is normally paid from the sale proceeds. That means money comes right off the closing table, not into your pocket, into the IRS balance. Now, tools exist. You can apply for a discharge of the lien from specific property using Form 14135. You can apply for a subordination, letting a new lender move ahead of the IRS in priority using Form 14134. You can even request a withdrawal of the filed notice using Form 12277 if the lien has been resolved. But none of these happen automatically. You have to know the form, file it with the right IRS advisory office, listed in publication 4235, and do it with enough lead time before your closing. There is no single national deadline I could find for how far ahead you need to submit. Discharge or subordination applications tied to a closing. And here is something that matters. Your primary residence cannot be seized by the IRS without court approval and a showing that there is no reasonable alternative to collection. That is a real protection. But a lien and a seizure are not the same thing. The lien does not take the house. It sits on the title and quietly takes your options, your ability to sell cleanly, refinance freely, or pass on full equity. Who does this help most? The comfortable group. You're the one most likely to have real equity and to assume you can fix this at closing. This item says maybe, but not without paperwork, not without the right office, and not without money off the top. The math. Say the underlying tax shortfall runs about $291.67 a month. That's $3,500 a year. Leave it alone for 5 years and you're looking at $17,500 that can come right off the closing table. Here is your action step. If you're planning to sell or refinance and you know there's a federal tax lien, call the title company first and ask what IRS lien paperwork is needed for closing. Then contact the IRS Collection Advisory Office through publication 4235 and ask, I have a federal tax lien on property that I need to sell or refinance. Do I need a discharge or subordination application? And which office should receive it? If you want to challenge the lien filing itself, you have 30 days from letter 3172 to request a CDP hearing using Form 12153. That window is firm. That is number two. That was the federal side. The next one is local, quieter, and often more personal. Number three, the county property tax sale clock. Now, everything I've covered so far is about federal tax debt and the IRS. This next one changes what you're watching, because your county operates on its own calendar, with its own rules, and it does not wait for the IRS to go first. I need you to hear this one carefully. Most people with a paid-off house believe that house is safe. No mortgage, no lender, no one to answer to. The assumption is that a property tax bill is a nuisance, not a threat. That assumption can cost you the house. Here is how it works, and it works differently everywhere. Counties and tax collectors can move from unpaid property taxes to a lien sale, a tax certificate, a tax deed, or a foreclosure process depending on local law. There is no single national rule. That is exactly what makes this dangerous. The timeline depends on where you live, and the only reliable source is the notice sitting in your mailbox. Let me show you what local really means. In Palm Beach County, Florida, the tax certificate sale must be held 60 days after delinquency, or June 1st, whichever is later. In California, Property becomes tax defaulted if taxes remain unpaid at 12 o'clock a.m. on July 1st, and after 5 years tax defaulted, the county tax collector can sell the property. In Snohomish County, Washington, property is eligible for a 2026 tax sale if at least 1 year of property taxes is 3 years old and delinquent. Unpaid full year 2023 taxes as of June 1st, 2026 can put the property on the list for a mid-November 2026 sale. 3 states, 3 completely different clocks, and the person most at risk is often a surviving spouse who never handled the tax bill, or a homeowner who lost the escrow account when the mortgage was paid off and didn't realize the county was now billing them directly. Who does this help most? The fixed income group. A county tax bill can be small enough to set aside for a season and big enough to start a sale clock later, especially after a spouse dies or an escrow arrangement ends. The math. Say the property tax runs $250 a month. That's $3,000 a year. Over 5 years, that's $15,000. And in the wrong county timeline, the sale process can start long before you ever reach that total. Here's your action step. Call the county tax collector or treasurer the same day you get any delinquency notice. Ask 4 things. I need to know my exact delinquent balance, the next sale date, the redemption deadline, and every payment plan or senior relief option that can stop the sale. The office and phone number are on the notice itself. If you think you may qualify for a senior exemption or hardship program, ask the county assessor as well. Viewer state and county redemption period, sale trigger, hardship form, and payment plan rules. The county does not care which spouse used to pay the bill. The sale calendar does not pause because nobody explained the process in plain English. That is number 3. If you think a reverse mortgage removes this kind of danger, the next item is where that assumption breaks. Number 4. The reverse mortgage that still expects taxes, insurance, and upkeep. Here is the misconception that costs people their homes. No monthly mortgage payment means the house payment problem is gone. A reverse mortgage, specifically a HECM, a home equity conversion mortgage, which is the FHA-insured version most people have, eliminates the required principal and interest payment. That part is true. But it does not eliminate property taxes. It does not eliminate homeowners insurance. It does not eliminate flood insurance if you're in a flood zone. It does not eliminate HOA dues or basic maintenance. Every one of those bills is still yours, and every one of them is still due on time. HECM borrowers may remain in the home indefinitely, but only as long as property taxes and homeowners insurance are kept current. That is not a suggestion. That is a federal rule. Property taxes, hazard insurance premiums, and applicable flood insurance premiums must be paid on or before the due date, through a set-aside account called a LES, through direct borrower payment, or through a servicer advanced payment when the rules allow it. Now here is where it gets quiet and fast. If the set-aside funds run out and a property charge goes unpaid, the servicer must provide written notice to the borrower and to FHA within 30 days. The CFPB says it plainly. Failure to keep taxes or homeowners insurance current may lead to foreclosure. That word, foreclosure, on a loan that was supposed to free you from housing stress. There is a protection worth knowing. HUD's 2023 HECM Servicing Update expanded servicers' ability to work with borrowers who are behind on property taxes or hazard insurance by amounts up to $5,000 without immediately calling the mortgage due and payable. That flexibility is real, but it is not automatic, and it is not unlimited. You have to engage. Who does this help most? Both groups. It hits the fixed income HECC borrower hardest because $400 a month in taxes and insurance is a real weight when cash is tight. But it also shocks the comfortable homeowner who told their family the house is taken care of and didn't realize taxes and insurance could still trigger a default. A woman I heard from had exactly this misunderstanding. Elaine, 76, outside Tampa, retired bookkeeper. She had a HECM and thought the reverse mortgage meant the housing cost problem was solved. After her husband died, she missed property taxes and insurance, about $4,800 a year. She contacted the servicer and a HUD-approved HECM counselor immediately, asked whether a repayment plan or other loss mitigation option was available, and got moving before the loan advanced further toward due and payable status. The specific workout terms depend on the borrower's situation, but the action channel is real, and it only works if you pick up the phone before the servicer's hand is forced. $400 every single month, $4,800 a year. Over 10 years, that is $48,000 in taxes and insurance that the reverse mortgage never erased. Here is your action step. Call the servicer. The number is on your statement or on any notice. And call a HUD-approved HEAS-M counselor. You can find one through the HUD counselor search page or by calling 1-800-569-4287. Use these words. I have a HEAS-M and I am behind on property charges. I want to know whether I qualify for a repayment plan or any other loss mitigation option before this loan is called due and payable. Property charges are due by their own local due dates, and the servicer's written notice can go out within 30 days of identifying the outstanding charge. Do not wait for that notice to arrive. The reverse mortgage does not turn taxes and insurance into someone else's problem. It turns them into a problem with no monthly mortgage bill next to them to remind you they exist. That is number 4. Everything so far is about holding on to the house while you are alive. The last item is what happens when the system waits and comes for the house later. Number 5. Medicaid recovery and the quiet lien families do not expect. This is the one I told you to stay for, and it's the one most families discover too late. Here is the misconception. If the house was exempt when Medicaid approved coverage, it is protected forever. That is not how it works. A home can be excluded for Medicaid eligibility purposes, meaning Medicaid does not count it against you when you apply, and the state can still come back for it later. The rule is called Medicaid estate recovery. For people 55 or older, states are required by federal law to seek recovery from the estate for nursing facility services, home and community-based services, and related hospital and prescription drug services that Medicaid paid for. That recovery happens after the Medicaid recipient dies. The home was protected while you were alive and eligible. It is not necessarily protected once you're gone. Now, there are real protections built into this. If a surviving spouse is still alive, the estate is exempt from recovery at that point. A state may recover later from the spouse's estate after the spouse also passes. A child under 21, or a blind or disabled child of any age, or a sibling with an equity interest who lives in the home. These can defer or block recovery too. And heirs can seek a hardship waiver. These protections are real, but not one of them activates on its own. The family has to know they exist and assert them. Here's the part that surprises people even further. States may also impose a lien during the lifetime of a permanently institutionalized enrollee, meaning before death, as long as the proper notice and hearing process is followed. The exceptions are the same: a spouse, a child under 21, a blind or disabled child, or a qualifying sibling in the home. And if the person is discharged from the institution and returns home, that pre-death lien dissolves. But the hearing must happen. The notice must be responded to. Who does this help most? Both groups, and both for the wrong assumption. Fixed-income families often believe the home was fully protected because it was exempt at eligibility. Comfortable families often assume estate recovery only targets people who had nothing. Both assumptions break here. If Medicaid paid for long-term care type services after age 55, the state has a federally required path to recover, regardless of how much or how little the person had otherwise. The math. Use a simple example. If Medicaid paid $2,500 a month for long-term care services for 2 years, that is a $60,000 recovery claim that can hit the estate later. That is not a cap. That is not an average. It is an example of how fast the number climbs. Here is your action step. If a family receives a Medicaid recovery notice, contact the state Medicaid Estate Recovery Unit immediately. Ask for the exact claim amount, the hardship waiver rules, and whether recovery is deferred because a protected spouse or child is involved. Use the state Medicaid website or the ACL Medicaid Estate Recovery page for baseline rules. Say these words: I need the Estate Recovery Unit, the exact claim amount, the hardship waiver rules, and whether recovery is deferred because a spouse or protected child is living. The hardship waiver deadline and hearing window vary by state. Nobody from the state Medicaid agency calls the family in advance to explain these rights. The claim arrives and the clock starts. That is number 5. So here is the full picture. The first risk is the federal tax debt that starts quietly with underwithholding and turns into a lien. One Form W-4V or one payment plan can stop it. The second is the lien filing that can follow the house into a sale or refinance. One call to the advisory office and the right discharge form can clear it. The third is the county property tax sale clock that can start with a bill a surviving spouse never knew was unpaid. One call to the county with 4 questions can stop the sale. The fourth is the reverse mortgage that cancels principal and interest payments, but never cancels taxes, insurance, or upkeep. One call to the servicer and a HUD counselor before the loan is called due. The fifth is Medicaid recovery, the claim that waits until later, then shows up when the family thinks the house is being passed on. 1 call to the State Estate Recovery Unit to get the waiver rules and deferral status. 5 risks, 5 phone calls, none of them automatic. The IRS does not stop because you meant to fix it later. The county does not care which spouse used to pay the bill. The reverse mortgage does not turn taxes and insurance into someone else's problem. Medicaid does not turn an eligibility exemption into permanent protection. And a house with equity is not a house outside the reach of liens. Being legally entitled to time, relief, or a way out, and actually using it are two completely different things. The gap between them is information. Now I want you to picture one person, a widowed parent, a neighbor with a paid-off house, a friend from church who has a reverse mortgage and says the house is finally taken care of. Not because they're struggling, because one missed notice in one of these systems is enough. Share this with one person who owns a home and is over 63. Subscribe, and I'll see you in the next one.